Punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes,
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Seguno gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that correct, state and defense?
No objection, state judge.
All right, so the court has reviewed all of those documents.
Your Honor, I also raised that the part of the agreement of coming back today was that the misdemeanor occurred on the same day of this alleged date. Was to be taken consideration with CC County Court 4 case 69-3701.
Yes, and the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right, so my understanding, the complainant in this case is Rebecca Martinez.
Yes.
All right, and is that the Rebecca Martinez who's on the fourth court?
Yes, Judge.
Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues, and when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right in this case, so no objection.
All right. So are there any witnesses that anyone wishes to present, state?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant,
All
which the court has already noted that they've read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter, I will be speaking and Ms. Seguno may say a couple of words, and Ms. Seguno's parents are present in support of her today. They can stand with like Mr. is standing here in support of her today.
All right, thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Gracie Segunda.
All right. And with regards to County Court Cause number 6933701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just so nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
I will go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 6933701, how do you plead to that? All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? So the court then will hear argument. State you're opposed to deferred adjudication.
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. It was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense.
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career in taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of. It was just something in her reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agree to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely has nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
No, I'm nervous.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I don't know, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity, people need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that fight.
I went to go and try and pull my friend away and then like I don't know, it was just a bunch of people and somebody hit me and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's what we're here 2 years later doing that. In addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. You want to see it, Judge? It's public record.
I would object just because relevance.
It's a lawsuit and filed in the city court. That's a copy from the courthouse.
All right, unless there are some facts that are listed in the,
It pleads the
Lawsuit.
whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, well, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will,
It does not, Judge.
all right, so,
But just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right, anything else from either side?
No, Your Honor.
No.
All right, I've read your letters that were presented, and it appears that, you know, other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out?
Us just walked in at once.
All
And
right,
then
and then you were asked to leave.
they said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
True. You didn't decide that.
Yeah.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator. I'll take the stairs. I don't understand.
We had already gotten off 2 floors, so we said like we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved or people just don't want to take
It
the
was after a
stairs?
football game, Judge.
State, does anybody want to, I know the complainants are here. Do they want to
No,
say anything to the court?
no.
Okay,
Oh, Your Honor, may I have one moment?
yes. And then after this, we're going to take up Pete Diaz, Emmanuel Castro, Michael Martinez, Larry Berry, and Michael Moore. Okay,
Your Honor, he's not a victim in this case. Why would he come to?
I mean, we'll see what he has to say. I don't know if he's a relevant witness or not, but if he were present at the scene.
You know, I would think that the person involved is the one who's, in this case, is the one that would need to address it. He's had his day in court. He has spoken before the court. I don't see why he needs to speak in this case at sentencing.
All right, you can call your witness.
State calls David Martinez.
You're welcome. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
David Martinez.
All right, state.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 18. But because of the COVID era, there was an elevator attendant there. She said only 8 could be allowed in. We were 3 couples and 2 children, which were a total of 8. As we walked in, we were already in the elevator. They decide to come in behind us. The elevator attendant told them they need to step out. It's full. They had been intoxicated. Her friend. stepped-
Objection, speculation.
Overruled.
No, they were
No.
intoxicated.
Yeah, here's the thing. You cannot address the attorneys. Once an objection is, no problem. Once the objection is raised, just stop speaking. I'll make a ruling on the objection. And then I'll let you know if you can continue or not, if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing. Began to.
Objection, Your Honor. I just asked for clarification from the ones. I don't know who he is.
Which he are you speaking about, sir?
Her partner, there was 2 gentlemen, which was the initial one that started arguing with us. And her partner that she was mentioning that walked in and they were not, we were already in the elevator already when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, that it was BS, that they cannot be let in because there was a lot of room. And she told him he had to leave. He continued to argue with her and he said that he wanted to talk to her supervisor. And she says, if that's the case, she shut off the elevator. And that's when words were back and forth. They continued berating us. She was cussing like a sailor as well as the other ones. We kept quiet and they started again arguing with us. We stayed in there. The kids were already getting terrified with what was going on. They started crying and they continued with their vulgar language. And I just told them one time, that's it, F you. The gentleman that was with him got upset. He literally from the outside ran into the elevator, knocked us all over and, assaulted all of us in there. I grabbed him and I pushed him out. It was not the individual that she says was in there. It was the other individual that was with him that probably hosted them to the game. And he and I went outside and after that, what?
From there, sir, is that where everything happened?
Correct.
Pass it with this judge.
Any questions?
Mr. Martinez, I'll just start right from leaving the elevator. So by the time that you set foot out of the elevator, you're in the middle of a physical altercation. Is
I
that right?
was, yes, while I was on the ground.
Okay. How much were you able to perceive about what was happening around you while you were in the middle of that?
Well, I was
altercation?
on
If
the
you
ground.
let me finish my question.
All right, it's,
One at a
we're gonna
time,
talk.
sir.
So my question was, how much were you able to perceive about what was going on around you during the middle of that physical altercation?
And I was not able to see when I was in the ground, what was taking place after that.
Okay, and we can agree that the incident in question, the basis of this criminal case here today is something that happened during the middle of your physical altercation, right?
While I was on the ground, yes, and then afterward, I did get up and partially saw my wife on the ground with a bloody nose. She was in a daze and I asked her what happened. And I told her that she got hit. She said, yeah, I got hit multiple times. And I said, well, why didn't you defend yourself? She says, I couldn't because I was being held down.
Can you say for certainty whether or not Mrs. Segundo was acting in defense of another whenever she got involved in this incident?
I'm gonna object to relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't say that, but I can't answer.
Oh, and I understand, Mr. Martinez, the want for justice on behalf of the injuries for your wife. I just want to make sure that we're also serving justice here for Mrs.
Absolutely.
Segundo today based on her amount of involvement in this incident. And
There was
so-
no, go ahead. I'm sorry.
Go ahead, please. finish.
No, there was only 2 other parties involved, 3 parties, and the individual who was with me had already left. But it was only her left with her friend. And there was nobody else around. There was people watching, nobody wasn't getting involved, but they were the only ones actively, physically getting involved.
But, and I know we started this conversation based off what's happening when you're leaving the elevator. Prior to the altercation and leaving the elevator, would you say that in any way Mrs. Segundo was the instigator who was trying to start this situation? I have no further questions.
All right, any other questions?
Nothing from the state, Judge.
All right, thank you.
This is-
All right, any other witnesses?
No, Your Honor.
All right, the court will hear final argument, if there is any.
Your Honor, I think it's clear that Ms. Segundo did not start this incident. That her actions occurred outside the elevator as a result of defending another person. She doesn't deny that she struck Ms. Martinez, but this was a situation where she was struck as well. And we believe that this one incident that wasn't premeditated, it wasn't started or caused by her. You know, it reminds me of a penalty and another individual comes in their aid and then another flag comes up for a penalty and they both get penalties. And most cases in sports, that's offsetting. And I think in this case, at looking at the situation, looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her with her children, with her workplace. We can't promise that she will keep her job upon this conviction. We cannot promise that she can be able to parent her children and be the primary caretaker of her children as a result of this conviction. But we can promise that if she is given a chance, she will do everything in her power to remain on probation for 7 years. To do what's right, so not to be considered a felon in a situation that she wished never had happened. There's no ill will here. There is no desire on her part to do anything but to move on with her life and pay what's owed, the $2,500, and do what it takes to win your trust. So we're asking, Judge, that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and her work and her community.
Any final arguments?
Your Honor, the concern from the state here is, again, the facts of the case. It's that, yes, she wasn't the instigator, but she chose to take it to this level. It was her choice to take this out on the complainant. It was her choice to get involved against the complainant and to not show restraint. It's the issue that this all started over something very trivial, that if just a little bit of patience, this would have all passed over. That moment that she decided to act how she did has affected the complainant from that day until today. And it's going to affect her past this. That's why the state is asking for probation on this case and for you to not grant her deferred adjudication.
All right, so what is the amount of restitution and who is the restitution to?
It's to Rebecca Martinez and
$2,416.29.
Wait, 2,400?
$16.29.
And also in the plea bargain agreement, it says restitution to,
Jeanette Rojas.
yes.
Your Honor, so we haven't gotten any medical or billing from there. We would ask restitution to be determined on that amount.
All right, so with regards to the restitution to Jeanette Riojas, if there's a restitution amount that's submitted to the court and you all have objections to it, we can have a restitution hearing.
Thank you.
And I'll just write in that there's to be a restitution hearing as it relates to Jeanette Riojas. And I'm assuming she's going to want to transfer to Houston.
Yes, Your Honor.
And what?
It's in Harris County.
All right, Ms. Segunda, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean that the person is a horrible person. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at is the fact that the complainant has serious injuries. And it has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example. Then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries, and I've read the PSI report, and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this, I can't do that, I can't do this. But then when you look at the complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. And I think you know that when people have broken bones, there's a change in the weather, their bones ache. I have it with my fingers because at one point in time, all of my fingers were broken on my left hand. So I know when the weather is changing, it gets a little bit painful, not unbearably painful, but it does. So those are a whole host of things that happens when somebody suffers the injuries that she suffered. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you would. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas, Harris County. Taking consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yeah.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another day to argue about it. You understand? All right, good luck to you.
Thank you.
Pete Diaz Haynes,
Yes, ma'am, y'all.
you entered a plea on September 8th, a no contest. You applied for probation. The state recommends probation according to the plea bargain agreement. And there are cases to be taken in consideration. Was a PSI completed on this case?
It was, Judge.
Have both parties had a chance to review the PSI report state?
Yes, Your Honor.
Defense?
Yes, we have, Judge.
All right, any objections to the PSI report?
No, Judge, just argument.
All right, and just give me one moment. Let me pull up the PSI report. All right, the court will hear argument.
So, Judge, I reviewed the PSI and TAP with my client. The TAP I was kind of concerned about because it recommended ISF, substance abuse and cognitive track. But I didn't notice, I don't recall any issues on the PSI or on the offense involving drugs or alcohol or anything in the TAP where the client made any sort of admissions about drug or alcohol use. I was just going to ask the court, he's been incarcerated for 6 months. He and the complainant have 2 children together. He has a job waiting for him. He's going to be living with his brother. And I'd ask the court to let him do, I guess, intensive outpatient if the court does think he needs some sort of monitoring for treatment and perhaps UAs and allow him to get back to work so he can try to provide child support for his family in light of the state's recommendation.
All right, state.
Just with respect to ISF or outpatient, we just defer to the court and ask that you follow the agreement, and the state will defer to the court on that specific issue.
All right, so in the report, there's a no contact order with the complainant. So the court, it does not remove no contact orders unless the court has information from the complainant and the court is assured that the complainant is safe. So that no contact order is going to remain.
I think she noted she wanted that I think that's part of the, she gave a statement in the PSI stating that she didn't want to come to court, but she wanted the no contact order to stay in place. So obviously if they have some sort of change in the future, he'll need to get a lawyer to approach the court about it.
Okay. And state, is the complainant aware that he is going to be released today?
Yes, Your Honor, I believe that's correct.
She noted that in the she was okay with the probation.
All right, and how old are the children?
3 and 4.
Where are you gonna, can you raise your right hand for me, please? Do you
Yes, ma'am.
solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Larry Haynes,
All right, Mr. Haynes, who are you going to be living with?
my big brother, Sherman Johnson.
Does he know you're going to be living with him?
Yes, ma'am.
Does he want you living with him?
Yes, ma'am.
Does he have any children?
No, ma'am.
Is he living by himself?
No, my sister-in-law.
Okay. Does she want you there?
Yes, ma'am.
Okay. And what employment prospects do you have?
I can go back to work at HEB warehouse on off of Riddiman Road and I-35.
Okay. And is there a child custody agreement in place?
Have you all been to court? Do you have a lawyer at the AG's office or
Oh,
something?
no, we both have our rights. We both have our rights to custody and everything, so.
The question is there a court order? Did y'all go to court and have a
no,
judge
no.
impose it?
All right, so you all are just dependent on each other to be fair with,
Yes, ma'am.
okay.
Sorry.
All right, this is what the court is going to do. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. Take in consideration the following cause numbers: 2019 CR 6035, 2022 CR 0842. There's an affirmative finding of family violence. There's to be no contact with Rowena and Suarez. I understand that you all have children together, but what you'll have to do is that will have to be arranged through a third party. You understand?
Yes, ma'am.
Of course, if something, God forbid, something were to happen and there is an emergency,
Yes, ma'am.
the probation will let me know that you've had contact, but then they will tell me there was an emergency, they were at the hospital or something of that nature. But other than that, you're not to have any contact. You're not to be contacting her through third parties. Do you understand?
Yes, ma'am, I do.
There is to be 200 hours of community service restitution. I'm going to want parenting classes. Once parenting classes are completed, the court will deem that the community service hours are satisfied. Regular reporting by Zoom or in person. Regular UAs. We're going to start with outpatient treatment with probation. Probation will do field visits one time for 3 months and thereafter as probation deems necessary. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. There should be no unsupervised contact with minors until you've had at least 2 parenting classes.
Yes, ma'am.
And they're asking, and it's listed outside the plea bargain agreement, but this is an assault case. So I'm going to grant the BIPP program unless defense, you have a reason why that shouldn't be.
Judge, I don't think so. I mean, I think it's probably appropriate based on the circumstances.
All right. And the BIPP course. Probation, is there anything else he needs?
In order for me to do outpatient treatment, I need a tap.
It was completed.
Oh.
Yeah, no, we'll start with regular outpatient and then we'll see what happens. All right, Mr. Haynes, is there anything else you need from the court to be successful?
No, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Okay. Because this is a felony conviction, because this is an affirmative finding of family violence, dismissal.
Yes, Judge, I have them.
You are not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Yes, ma'am.
Because this is a plea bargain agreement and because I followed your plea bargain agreement, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing about relationships. If you're in a relationship where somebody started to check somebody else's phone because they don't trust them, then that means you have no trust in the relationship and maybe that relationship should be done with.
Yes, ma'am.
When you have children, I don't know if your child is a girl or a boy.
A girl and a boy.
All right. So children learn by what they see in a household.
Yes, ma'am.
So if you have a daughter who sees their parents fighting or the father being abusive to the mother,
Yes, ma'am.
that child will think, well, he loves her. That's what I'm being told. So this is the way people behave when they are in love. And she may be accepting of that in a relationship because of you.
Yes, ma'am.
When you have a son and he sees that, he will think, this is how you show love to somebody. And I don't think you want that to happen. I don't think you want anyone to be putting their hands on your daughter, right?
No, ma'am, I don't.
And I don't think you want your son to end up where you are, correct?
No, ma'am, I don't.
All right. So if there's anything with probation, you feel like they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right. Good luck. Go forth and do better.
Thank you,
Yes, ma'am.
Judge.
Thank you so much.
You're welcome. Thank you.
Yes, ma'am.
2020 CR 4576, State of Texas versus Juan Manuel Martinez. Can I have parties announced for the record for the state?
Laura Metzold for the state.
Defense?
Paul J. Smith for the defense.
Are you Mr. Martinez?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Juan Manuel Martinez who was placed on deferred adjudication in 2020 CR 4576 for the offense of robbery on December 16th, 2020 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant Juan Manuel Martinez did then and there fail to report to the supervision officer as directed for the months of October, November 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
And we'll waive the remaining violations, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, there is.
Yes.
Revocation and adjudication and sentenced to 5 years in Texas Department of Corrections.
Defense, is that the agreement?
It is, Your Honor.
Mr. Martinez, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Juan Martinez,
All right, so why didn't you report?
because I had a DWI, I had drinking. I didn't want to get my probation revoked and have my dad work the whole summer, knowing that he needed my help. So I know that I failed to report because I didn't want to.
And when did you pick up the DWI? Is this December 26th?
Yes, Your Honor. On Christmas or Christmas night.
But then that doesn't explain why you didn't report in October. Because you wouldn't have had the DWI until December. All right, because it's saying here that you didn't report for the months of October and November. And according to this, which I'm not saying it, taking it as true, but according to this, allegedly, the DWI case didn't come till December 2022.
Yes, Your Honor. I'm not too sure.
All right. Has he done anything on probation?
I mean, he picked up number one. So we did
Yeah, I
that.
mean, yes.
Your Honor, this is his second MTR. As far as what I can tell, he has not done anything. He hasn't completed any of his community service hours. I will say he did pay $1,241 of his $7,625 assessed fees. Other than that, no, ma'am.
All right.
There was a negative UA back in December of 2022, diluted in September of 2022. There was a positive in January of 2022.
All right. And with regards to the restitution, was any ever tendered to Mr. Antunes and Miss Villalobos?
Your Honor, there isn't anything under the financial portion that indicated there was restitution, actual restitution numbers, the amount for restitution, so more than likely not.
Okay. All right. The court will find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You want to walk around?
I want to touch the microphone.
Thank you. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Martinez, how old are you?
26.
All right, you're gonna have to start doing better, because otherwise you're gonna find yourself in and out of somebody's jail and in and out of prison. If you have a drug or alcohol problem, I can request that you be placed in the therapeutic community. Whether they accept you or not will be completely up to them, but at least they can help you address any alcohol or substance abuse issues you have. Would you like that?
Yeah.
All right, so I'm gonna add therapeutic community to his sentence. You'll still need to request it. It doesn't increase the length of time that you've been in custody. So for example, if they're going to release you in 5 years and you're still working on your substance issues, they're not going to say, oh, we're going to keep him. You understand? All right. All right. Good luck to you.
So, thank you.
All right. The court is calling 2023 CR 5468, State of Texas versus Johnny Aguirre. And this is Criminal Trial Division. Shall parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Renee Munoz on behalf of Mr. Aguirre.
And are you Johnny Aguirre?
Yes, ma'am.
All right, you entered a plea. You entered a plea on September 12th. You applied for deferred adjudication. And according to the plea bargain agreement, the state is recommending deferred adjudication. We are here because a TAP evaluation was requested. Have both parties had a chance to review the TAP evaluation?
Yes, Your Honor.
Yes, Your Honor.
Does anyone wish to speak to the TAP evaluation?
Yes, Your Honor, if I may briefly. I did speak with probation about the recommendations in the TAP. I know that DDRF is listed there for inpatient. I also know that it's approximately 6 to 13 week wait. My client has admitted to the court openly and honestly that he has issues with the methamphetamine use, Judge. So we would like a request in lieu of DDRF if we can possibly consider for lifetime recovery. It is an inpatient facility where he would get drug help as well. It would be likely less of a time frame of him waiting in the jail. And we also had since the court had sent a referral for drug court. We did get a response back that he does qualify. However, unfortunately, this time there is a wait list. So I did speak with the case manager, Paul Manriquez, and he said that he would notify me and the probation officer when some space was available because they're going to have graduation coming up soon. Judge
All right,
Flanagan's.
When did you speak with them? Because they recently had graduation.
I sent an email out last week and they stated that he did qualify. But they presumptively rejected him because he had not been ordered to probation formally yet.
So there were two issues, Your Honor, if you may. He was not granted probation yet, so he could not be put on the wait list. And they have not received all of the funding and everything that they need. So there is no available spots right now, even though we just had graduation, is what they've told.
All right, so will lifetime recovery be a good fit for him?
Yes.
All right, is there anything else from either side?
Nothing from the state, Judge.
Nothing further from the bench.
All right, so Mr. Aguirre, I'm going to follow your agreement and place you in lifetime recovery. But you're going to have to make sure that you stay on your medications.
Yes, sir.
And if there's an issue with your medication where it has a side effect of something of that nature, then you need to let your doctor know, and maybe they can give you something that doesn't have the negative side effects. You understand?
Yes, ma'am.
All right, so this is what the court will do. The court will sentence you to 5 years deferred adjudication. There's a $500 fine that will be probated. I'm going to order lifetime recovery and probation. If you could let felony drug court know that he's starting with lifetime recovery, maybe they can eventually find a place for him. Felony drug court is a great program because they will help you with any mental health issues as well as any drug issues. That's why I'm pushing for it. You understand?
Yes, ma'am.
There will be taken in consideration County Court Cause number 703-653, 716-121, 200 hours of community service restitution, regular reporting, that's by Zoom or in person. And I know lifetime recovery does UAs.
Yes.
So probation, if you want to accept lifetime recovery's UAs, you can. But I'm going to order random monthly UAs. No contact with 8923 West Military, San Antonio, Texas, 78245 and 6550. Enrique M. Barrera Parkway. And that's 78201. Proof of employment or SSI within 60 days of release. There's to be no employment as a home health care provider or with minors. And then upon release from lifetime recovery, field visits 1 time per month for 3 months. And then as probation sees fits. and he's to be transferred from the Bear County Jail by lifetime recovery. Probation, is there anything else he needs?
No, Your Honor.
Mr. Gary, is there anything else you need from the court?
No, ma'am.
All right, I'm going to show you what's entitled trial court certification of defendant's right to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
If at any time you feel as though probation is not communicating with you or there are some issues with lifetime, you can always let the court know. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Maybe excused.
Yes.
Morning, Judge.
Good morning. Court is calling 2017 CR 4326B, State of Texas versus Emmanuel Castro. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense?
Stephen Hartwich for Emmanuel Castro.
Are you Mr. Castro?
Yes, ma'am.
All right, I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
No.
Are you the same Emmanuel Castro who was placed on deferred adjudication in 2017 CR 4326B for the offense of possession of marijuana, 4 ounces to 5 pounds on September 6, 2017 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5. In Bear County, Texas, the defendant Emmanuel Castro did then and there fail to report to the supervision officer as directed for the months of June, July, August, September, October, November, and December 2018 in violation of condition number 5.
Just one moment. I don't have that motion. Is that a supplemental?
No, it's on the, oh, sorry, it is on the supplemental, Judge. I apologize.
All right. Mr. Castro, I'm going to show you what's entitled state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney as well and understand it?
Yes, ma'am.
All right, then to violation of condition number 5, how do you plead, true or not true? State?
And then on violated condition number 5, the second one, Your Honor, in Bear County, Texas, the defendant Emmanuel Castro did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December of 2019 in violation of condition number 5.
How do you plead to that, true or not true? I'm sorry, you need to.
And we'll waive the remaining violations, Your Honor.
All right, any objection?
No, Your Honor.
Did you understand by pleading true to violations 5 and 5, the court could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to 5 and 5?
Yes, ma'am. Sorry.
Court will find 5 and 5 true. Is there a proposed agreement?
Yes, Your Honor, there is. For revocation and adjudication and to proceed forward on sentencing under 1244A for 45 days in the Bear County Jail.
We're just gonna recommend 9 days.
He says on his credit for 45 days. Give me 1 second, Your Honor, because it's not my offer.
All right, so what are you?
Because his agreement on here says for 45 days, and so I'll just need to verify with him that he changed it to 9 days. Yeah, his offer is for 45 days on here, so I'll need to verify with Daniel, because he didn't make any changes on here to verify that he agreed for the JSOC.
All right, so here's the question. Why should I give him 45 days or even 90 days under 1244? Has he done anything?
Judge, as a condition of his bond, you asked him to take sober
Support meetings?
support meetings. He did attend that. Would you like to approach her?
Yes. Any objections to the court?
No, Your Honor. Also, Daniel Escobar from the state of Texas.
So what is the proposed agreement?
It was for 9 days in the Bear County Jail under 1244, Judge.
9.
And probation was recommending judgment unsatisfied. So
All right. And how much time does he have in?
I think 9 days.
9 days, Judge.
All right, I don't think 9 days is appropriate. So, I mean, you're gonna have to go to the Bear County Jail. You understand? All right. So what I'll do is I'll grant the motion, find him guilty, and sentence him under 1244. And I'll sentence him to 30 days in the Bear County Jail. And I'll give him credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, you have a limited right to appeal. That's as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. So here you go.
Sorry.
Court is calling 2021 CR 2125D, State of Texas versus Pete Diaz. Can I have the parties announced for the record for the state
Chandler Bowen for the state of Texas.
defense?
Cornelius Cox for the defendant.
And are you Mr. Diaz?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Pete Diaz who was placed on deferred adjudication in 2021 CR 2125D for the offense of theft $30,000 to $150,000 on September 29, 2021 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
We're proceeding on a violated condition 8B. On or about the 31st day of July 2023 in Bear County, Texas, the defendant Pete Diaz did then and there fail to report to the supervision officer on the next working day after being released from jail for a new arrest in violation of condition 8B.
How do you plead to that? True or not true?
True.
We'll waive the remaining allegations in the motion, Your Honor.
Okay.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
No.
Knowing that, do you still wish to plead true to violation of condition number 8B?
Yes, ma'am.
Court will find violation of condition 8B true. Is there a proposed agreement?
There is an agreement, Your Honor, subject to the court's approval. That is to deny the MTR, continue him on supervision with amended conditions, specifically to include the batter's intervention and prevention program, to continue his compliance with the San Antonio Fatherhood Program, to impose a no contact order with Jessica Contreras, to have the defendant enroll in intensive outpatient treatment, weekly UAs until he's testing clean, and then back to regularly or randomly scheduled UAs.
That's
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Yes.
All right, so what drug would you be positive for? That they're saying they're trying to wait till it gets out of your system?
They say it was meth and opioids.
Mhm.
I haven't used any, at that time, everybody at the work was getting sick and I worked with a bunch of seniors. They had gave me different kinds of meds. I took it, but I understand that I shouldn't be taking anything, but I took they're all retired nurses, surgeon nurses, and
So you're just saying they just gave you free medication?
they saw me sick. I'm the maintenance man for them, and they're trying to, I guess, make me feel better. I should have just gone to the doctor, took some medication from there. I was taking all kinds of. My boss came out positive for COVID.
And who is Jessica Contreras?
She's my baby mother.
You mean the mother of your child?
Yes, two. Two girls. We're no longer together. She's moved toward Tyler.
So she's in a different city?
Yes, ma'am.
And what is happening with this new number 1?
It's going to be rejected, Your Honor, as part of this agreement.
All right, court will deny the motion. alternate amend conditions. To include the BIPP course, parenting classes. Is that covered on the San Antonio Fatherhood Program?
I believe it's a similar program, Your Honor.
All right, probation, if the San Antonio Fatherhood Program is similar to the parenting classes, then the court will accept that. The BIPP course. No contact with Jessica Contreras. So for any visitation, you'll have to do that through a third party. Do you understand?
Yes, ma'am.
Yes. So who is the probation officer for Mr. Diaz? All right, if you'll come forward, please. All right, so Ms. Martinez, with regards to Mr. Diaz, they're recommending the BIPP course, San Antonio Fatherhood Program, no contact with Jessica Contreras, and intensive outpatient treatment with weekly UAs. Is there anything else you think he may need, or have there been any other issues with him?
No, ma'am, that's fine.
Okay. All right, and so what we'll do is we'll do the intensive. I'm really torn on asking for intensive outpatient treatment because he's saying that the reason he tested positive is for medication that he was given where he works.
Yes, that's what he told me.
So have there been any other positives with him?
No, no, Your Honor, but we did get it confirmed and with the lab, and it did test positive for methamphetamine.
Well, is that from a medication?
It didn't say, it just said it was positive for meth.
All right, this is what I'm gonna do. Do you have a drug problem, Mr. Diaz? We're gonna do UAs. And we're gonna do weekly UAs. Or either we can do, or either you can do the patch. And then once he tests negative, we're gonna start with random UAs. And if there's a positive UA, then we'll see where we are. So there will be weekly UAs until a negative test is presented. And once it's negative, and can you test for levels to make sure things are not going up?
I believe it's only for marijuana. We test the levels.
Okay. Well, here's the thing. This meth should not be in your system after this week. Do you understand?
Yes, ma'am.
All right, so we'll do weekly UAs until he's negative. So I'm gonna want him tested every week. And then thereafter, it will be random UAs.
Can we do the IVR for the random?
Yes. So it'll be the hotline for the random UAs. Do you understand? Is there anything else you need from the court to be successful?
No, ma'am.
Is there anything else he needs?
No, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Yes. All right, court is calling 2023 CR 4008, State of Texas versus Michael Joseph Moore. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Suzanne Kramer for Mr. Moore.
And are you Michael Joseph Moore?
Yes, Your Honor.
All right, you entered a plea in this case on October 5th to count 1 of no contest. The state waived count 2. The court found that there was sufficient evidence to find you guilty. The state was silent on your application for community supervision. Because there is such a length of time for PSIs, the court just ordered your criminal history. And the court will use that as a basis on whether or not to grant your application. The state is silent. Anything you wish to say on behalf of your client?
Yes, Judge, just a few things. While on bond, I don't really remember what got us in front of you, but we were in front of you on something. And you had just given a recommendation to Mr. Moore that he might, while on bond, seek some treatment for himself, which he did do. He started going to Lifetime. and his got with a counselor named Peggy McIntyre.
Mhm.
And in fact, he was going to go into the inpatient section of Lifetime, but he got arrested, and I'll just remind the judge, it wasn't for anything other than Mark Garcia with A Action or Cowboy. I can't remember which particular bond company you were
Yes.
with, Cowboy. Although I had been here earlier that morning, he came in knowing I was here after I left and asked Judge Harrell to increase the bond because Mr. Moore apparently missed a check-in. So that's what got him back in custody and unable to participate in the inpatient program at Lifetime. But I also wanted him to because it sounds much better coming from him when he talks about how he was so upset about going to jail because he really wanted to get this help. He had no court order requiring to do it. He did it all on his own. If you would like to hear from Mr. Moore, he can speak with you.
Sure. If you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Michael Mora.
All right.
And Michael, I had talked to you about, you will be allowed to speak with the judge about your desires to seek help and why you went and got it, even though you weren't court ordered to do so. Did you let her know a little bit about that?
I just my counselor has just told me how would you feel getting impatient, and I told her yes, I'll do it. You know, I do it just, you know what I mean, just to get the help. And after I got enrolled, I started, my drug testing started coming out clean. I started coming out, you know what I mean, negative on my UA. So I felt like it was a good help and it was helping me.
So, I mean, I'm not sure that he's ever really had any kind of help before. I'm not sure that he's ever before. He's getting a little bit older now, had the desire to seek help, but he did it on his own. You did not court order him. I do not believe to do it as a condition of bond. And I think that speaks very well for his incentive to do well on this probation, if you so grant it.
Yeah, I don't have. All right, then. Just 1 second. I'm being told that you pled to 2 cases and I only have 1.
Oh, you know what? It was like 4,008 and.
Yeah, 4,008 and 3876, Your Honor.
Okay. All right, so they're gonna give that file to me. All right. So we're back on the record, and we're also on the record in 2023 CR 3876. Is that correct from both
Yes, ma'am.
sides? All right, and that's an evading case. All right, State, I know you're silent, but are there any fact issues you wish to bring to the court attention?
No, Your Honor.
All right, Mr. Moore, people say all the time that probation in this court is hard. And I guess it is, but I'm trying to do things to help people rehabilitate themselves so they will not be back in front of me again or in front of another court again. So you have a choice. I can grant your application for probation, or either I can sentence you to 5 years in prison on each of the cases. Which would you prefer?
Probation.
Okay. All right, this is what the court is going to do in each case, and the court will note the evading arrest and detention was evading an arrest on a bicycle.
Yes.
All right. So just one moment, just a correction for the record. The case involving the drug case was on a bicycle. The other evading was in a vehicle. All right, and each cause number, the court will sentence you to 5 years in the prison, suspended and probated for 7 years. Each case will run concurrently, and it will also run concurrent with 701883. Take in consideration 2023 CR 4009 and 689573. All right, do you have any children? You need to answer.
No, Your Honor.
All right. You're going to be inpatient treatment with lifetime recovery. And that's to be transferred by lifetime recovery. So once they pick you up, you'll be allowed to go. We're going to start off with GPS. And that'll be GPS for, let's do 4 months.
Will that be full or partial, Judge?
We're going to start off with full because he should be in his recovery at lifetime. And if
Okay.
lifetime feels that it's time for him to start working, they can approach the court.
Thank you, Judge.
And I'll ask that the fees are waived or deferred. There is to be the UA hotline and probation. I'm sure lifetime recovery is doing their drug testing as well. If you want to accept their drug testing for that, you can. Proof of employment within 90 days. There should be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors and field visits 1 time per month until further notice. And probation, with regards to field visits, if you all know that he's at lifetime recovery, you can just call or either accept the fact that he's at lifetime recovery. Probation, is there anything else he needs?
No, Your Honor. Are you regular recording via Zoom or in person?
Yes. All right, is there anything else you need from the court to be successful?
No, Your Honor.
Oh, and State, you can continue to confer.
Thank you.
You're welcome. And each cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because there's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Mora, this is your chance to get your life together. I will tell you, anytime you use drugs, you never know if that's going to be your last time to use. And if you are providing drugs to other people, that's not good either because you're building your happiness of somebody else's misery. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge. Maybe be excused.
Yes. Court is calling 2023 CR 4064, State of Texas versus Michael Martinez. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Albert Chidas for Mr. Martinez.
And are you Michael Martinez?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the lesser included. Assault bodily injury family.
Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand the state is proceeding on the lesser included offense of assault bodily injury family as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, on both.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 24 days in the Bexar County Jail. There are no applications. There's an affirmative finding of family violence, and if the court follows this agreement, it's the court's understanding that the judgment will be satisfied. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
All right. Did you understand that by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We are, Your
Anything you wish to say on behalf of your client?
Yes, Your Honor. We have a deal for time with the state, and I just want to make sure my client gets full credit for all the time that he's been in county. He's got 255 days here in Bexar County. But in addition to that, he's got 139 days out of Hidalgo County. He was held on at the request of Bexar County. And so he sat 139 in Hidalgo. Then he came here he sat in Hidalgo from June 2nd, 2023 through September 25th, 2023. Then he was booked here and he spent an additional 255 days awaiting trial.
Okay.
Or I should say awaiting the MTR.
All right. And state, have you spoke to the complainant?
We have, Your Honor.
And is she aware of this?
The complainant is not cooperative with our office.
And she did submit an affidavit requesting that he not be prosecuted.
Okay. Anything you wish to say, Mr. Martinez?
Just trying to consider the time that I've already served, in addition to what I owe still on the.
All right, court is going to find you guilty. There's an affirmative finding of family violence, 24 days in the Bexar County Jail, give you credit for time served. There's to be no contact with Christina Regalado, 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 and the court will find that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're going to move on to cause number 2020 CR 10481W, State of Texas versus Michael Benjamin Martinez, showing you what's entitled motion to revoke community supervision and state's motion to supplement pending motion. And state's motion to supplement motion to revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Michael Benjamin Martinez who was placed on community supervision in 2020 CR 10481W for the offense of assault of a public servant, bodily injury on October 29, 2020 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, there's an agreement between state and defense.
What allegation are you all moving on?
Violation number 7. On or about the second day of June 2023 in Bexar County, Texas, the defendant, Michael Benjamin Martinez, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true? Other allegations? Are you waiving those?
We're waiving and abandoning the others, Your Honor.
Any objection?
No objection. Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, and sentence you to 5 years in the prison? Were you aware of that?
It's 5/5, but we agreed to 4.
No, I'm just,
Oh, sorry, I don't know.
did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, sentence you to 5 years in prison? Did you understand that? And up to a $1,500 fine. Knowing that, do you still wish to plead true to violation of condition number 5? Court will find, knowing that, do you wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
There is, Your Honor,
Yes.
for 4 years, Your Honor.
What are you asking for?
We're asking for 4 years to do as opposed to the 5 underlying sentence.
And that is the case that he actually has the 255 days of credit here in Bexar County and the additional 139 days out of Hidalgo County for a total of 394 days credit.
All right. Was there any restitution in this case?
No, Your Honor.
All right, then the court will grant the motion and revoke. Are you asking the court to follow the agreement that's been reached?
Oh, yes, ma'am, please.
Are you waiving your right to appeal?
Yes, ma'am. Yes, Your Honor.
All right, the court will grant the motion, revoke, sentence you to 4 years in the prison, give you credit for any time served in Hidalgo County and Bexar County. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And you also are not allowed to own or possess any weapons due to your affirmative finding of family violence as well. Do you understand?
Sure.
All right, we can go off the record. You're going to have to do better with your life. You understand?
Yes, ma'am.
And when things are not working out with you with your significant other, you need to just leave. You understand?
Yes, ma'am.
All right, good luck to you.
Judge, I did want to just revisit one thing about the judgment satisfied case. I think you said no contact with Ms. Regalado.
Yes.
In her affidavit, she specifically asked that there be, I think she was under the impression there was a no contact order and she wanted it removed. So if we could have maybe no harmful or injurious contact.
I understand that you,
My common-law wife, like we've nothing set in stone with between me and her, obviously, because the whole deal. I understand the severity of everything, the family violence is not to be played with. She's thought long and hard about opportunity with me, and giving me a chance, and deciding, what we should do with the relationship, and we're deciding to work, all this out, but she is in agreement with, she really wanted me back on probation, but at the time is, I understand. And I have to do the time, we're just trying to work and fix all this. It would just be very strangeful if I couldn't do that. I'm gonna go to prison, so there's no way I'll be able to, go to her house and like do something, evil or whatever like that, whatever the deal is. But we're just trying to being able to reconcile and do all this, contact would really be necessary for that. I go about and take all the classes that I can, and that's what she wants
All
me
right,
to
can
do.
I see the file on the family violence case, please? I'll allow you to have phone contact with her. That's it.
And she did write on her affidavit,
No, I understand about that, Mr. Martinez, but here's the thing. I mean, you love her, right? She had bruising in the eye. And then I read the report. The report is not good. And I understand that tempers run high, people get in an argument. And then after tempers settle down, you know what the cycle is? Person will file an affidavit of non-prosecution. And sometimes cases will get dismissed because the complainant can't be found, and they found an affidavit, they've signed an affidavit of non-prosecution. Then you know what ends up happening? We have another assault case and we come back here, maybe somebody ends up dead, and then guess what people say? Judge, it's your fault. State, it's your fault. Defense, it's your fault. Why didn't we do anything? So the person I have standing before me right now, you have not taken any classes, right? Have you taken any family violence classes?
Yes, Your Honor, when I was on probation.
No, I mean, not just now. I mean,
recent,
yes.
trying to, I am in line to get in the anger management and family violence there at the jail. I volunteered for that myself. It's just that they told me on my kiosk, which I know there's records of that since day one that I got to Bexar County, and Hidalgo County didn't offer any of that. They didn't even have church there.
All right.
Out there, so or else I would have gladly, and that's one of the things.
What I'll tell you is I will allow phone contact only, because I'm sure she's probably going to want to put money on your commissary books, but there's to be no in-person contact. You understand?
Yes,
And the
ma'am.
phone contact, I'm just allowing it for her, not for you. And I say that because I know she wants to have contact with you. So yes, you will still be able to call her from the Bexar County Jail. She will probably accept your collect call. You probably shouldn't call a lot because that call costs a lot. I'm sure you're going to call her from the prison and she's going to want to accept your call. But I am ordering that there's to be no in-person contact with her. You can only have phone contact with her. You understand?
Yes, sir.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Darian De La Rosa. Hello. Hi. Are you all ready to proceed on this?
Yes, Judge.
All right, court is calling 2023 CR 4230, State of Texas versus Darian Renee De La Rosa. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Chair the show from Mr. La Rosa.
All right, and are you Miss De La Rosa?
Yes, sir.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, sir.
Are you the same Darian Renee De La Rosa who was placed on deferred adjudication in 2023 CR 4230 for the offense of robbery on July 17, 2023 for a period of 5 years? Is that you?
Yes, sir.
All right, state.
Violated condition number 2, on or about the 9th day of September 2023 in Bexar County, Texas, the defendant, Darian Renee De La Rosa, did then and there admit to using an illegal substance, namely marijuana, in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections?
Objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is for her to go to the DDRF program.
That is correct.
All right, and you're aware of the wait time for DDRF? All right, and I see, even though I'm not going to consider it, there are other allegations in the motion with regards to drug use. So what are we thinking the issue is? Is it mental health?
I think she just goes out and the community judge and hangs on for wrong individuals.
All right, so why are we saying DDRF instead of her going to drug rehab somewhere?
I mean, my understanding was that it was mental health plus drug issues, which DDRF will be able to address.
Probation? Miss De La Rosa, you guys are recommending DDRF?
Your Honor, that recommendation, came from Judge Flynn.
Okay, all righty. Then we'll do DDRF. And then after she completes that, see if they'll accept her back in felony drug court.
Yes, Your Honor.
So the court will deny the motion, alternate main conditions to include DDRF and a referral back to felony drug court after completion of DDRF. Is there anything else?
No, Your Honor.
All right, we can go off the record. Ms. De La Rosa, you're looking at 20 years in prison. Do you understand?
Yes, sir.
And when your counsel tells me the problem is you're hanging out with the wrong people, you know what those people would tell me? That they're hanging out with the wrong people. And I'll say, who is that? And they'll tell me it's you. You're gonna have to get your life together. This is serious. You understand?
Yes, sir.
All right, good luck to you. You're welcome.
To address that with the court for reinstatement. And then we're at a plea deadline, and I'd like to ask for an extension on that. May I approach with the documents, Your Honor?
All right, so let's address the case first. What is the reason for discovery? I mean, for extension of plea?
Judge, I think we're here at the plea deadline date. The
Mhm.
state has made an offer, and they've invited a counter. So since that offer, we've been working with a counselor. Miss Johnson is 17 years old, and we're working with a counselor to see if there's some mitigation that we can present to the state. So she got picked up last week, and kind of threw a wrench in our plan to get together with the counselor. So I just asked for 30 days to come back, and in the meantime, I'll talk to the state about a counter offer. She's 17 years old, serious charges, and we're just trying to work out the best possible thing we can. So that's where I'm at on that.
All right, Ms. Ferguson.
Yes, sir.
And this will be the last extension for a plea deadline day.
Very well, Judge.
Can I have a 30-day reset on Michaela Johnson?
Judge, can I throw in? I'll be out Thanksgiving week, so.
Oh, as will we.
Hmm?
We
Yeah,
will
okay.
as well.
Well,
I always try to give the staff extra vacation during the holiday times.
16th of November.
All right, November 16th.
Thank you for that, Judge. And Judge, may we address the bond violation?
Yeah, just one moment. All right, so now the violation.
Judge, I'm trying to understand it. We got notice of it, and I think it went to Judge Angelini, and he remanded Michaela without bond, and she was picked up. So she was, as a result of this case, she was placed in alternative school through the Northeast School District. She goes to Roosevelt, and she was attending some school on Saturday. She completed her alternative school, but was headed to her course on Saturday when she was notified that she did not have to go to school on Saturday. She
There,
was-
and here they're complaining about a McDonald's.
Right, so Michaela can answer your direct questions, Judge, but in a nutshell, she thought she could use the time to go pick up food for her brothers and sisters through her father.
All right, and then what is this with Montage Apartments and Marshall's Meadows apartment?
Yes, ma'am. So the.
Oh, I'm gonna have to put you on there. Oh, State, are you prepared to proceed on this?
Yes, Your Honor.
You have, you're asking that she remain remanded, or you all have discussed it?
So we discussed it. I think the state wanted to hear from her specifically as to what happened. And ultimately, I think we were going to be in agreement to allow her back on bond with the understanding that she's not to do these things. But we wanted to make sure this is actually what happened.
All right, can you raise your right hand? You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michaela Johnson.
All right, and just one moment. I know Judge Angelini has already ruled upon it for either. Oh, you know what, actually,
I printed those out for you, Judge.
thank you. All right. If you put that to Mr. Hancock. All right, does anybody have any questions?
I'll ask Michaela a few questions if I may. Michaela, you've had a chance to read the violation report. You've explained it to me. I think there's some specific addresses that the judge was going to inquire about. So why don't you just explain to the judge what your decision was once you found out you did not have to attend school?
Yes, sir. Once I found that I didn't have to attend school, I had got a call from my little brother and little sister that they were hungry, and I thought I could use the time. So I went to the apartments to grab money from my aunt. And on the way back, I went to the apartments to ask them what they would like from McDonald's, which is why I was at the McDonald's. And I went back. My Uber took a little longer than expected, which is why I was late home.
Okay. Any questions?
No, Your Honor.
All right, did her mom want to say anything to
No,
this?
Judge, I think we've addressed it. I just wanted you to know she has the support of her mom and is residing with her mom.
All right. And Stace?
So Judge, I understand what happened in the violation report. It does seem like her story did make sense. That's why I wanted to make sure that the court was able to hear and make a decision based off of what happened. The state's primary concern, again, we heard all this through her attorney, but it's something that I just wanted to make sure, was this the actual thing that occurred? Also to make sure that the court admonished her and made sure that this didn't happen again.
All right, so you're 17.
Yes, ma'am.
You have to realize when you're on GPS, you're only allowed to do what you're allowed to do.
Yes, ma'am, and I apologize.
So the proper thing to have done would have been to pick up the phone, call your pretrial services officer and say, I don't have school today. I just got a phone call from my siblings. They're hungry. May I go to McDonald's? And guess what? They're either going to say yes or no. When you're on GPS, it is not best to ask for forgiveness than permission. When you're on paper, everything is, you got to ask for permission, not forgiveness. Because I think the previous judge taught you that asking for forgiveness after not asking for permission does not work in court. Do you understand that?
Yes, ma'am.
All
Judge,
right.
I think her mom had called Mitchell bail bonds and they would agree to get back on the original bonds if the court would consider that.
All right, if you will call Mitchell bail bonds, because I can't reinstate the bond unless Mitchell bail bonds tells the court they're okay with the court reinstating the bond. So if you get in touch with them today, what I will do is I'll ask that the bond will be reinstated and you have your previous GPS conditions and you're only allowed to go to school.
Yes, ma'am.
Do you understand?
Yes, ma'am.
All right, so that's not going to happen until I get notification from your counsel that Mitchell is willing to go back on your bond.
Yes, ma'am.
Can I firm that in, Judge?
Yeah, if you want to call them now, you can.
I'll do that.
You're an officer of the court.
All right.
All right, thank you.
Thank you, Judge.
You're welcome. All right, court is calling 2020 CR 11096, State of Texas versus Joe Perez III. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense?
Michael DeLeon for Mr. Pettis.
And are you Mr. Perez?
Yes, Your Honor.
I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision and first amended motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Jose Perez III who was placed on deferred adjudication in 2020 CR 11096 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on July 20th, 2021 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, on the first amended motion to adjudicate probation, violation condition number 1, on or about the 7th day of September 2023 in Bexar County, Texas, the defendant Jose Perez III committed the offense of possession of controlled substance in violation of condition number 1.
All right, how do you plead to that? True or not true?
True.
And then violated condition number 1, on or about the 8th day of September 2023 in Bear County, Texas, the defendant Jose Perez committed the offense of possession of controlled substance in violation of condition number 1,
How do you plead to that? True or not true?
True.
and will waive the remaining violations, Your Honor.
Any objections?
No objection, John.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish please true to violations 1 and 1?
Yes.
Court will find violation of condition 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor, to alter and amend the conditions of probation with referral to drug court with SATF followed up with SATF aftercare, biweekly UAs, sober support meetings 2 times per week, and the TDOEP class.
Okay.
And as part of this agreement, we'll be TICing 2 new cases. Night mag number 729016 and 729015.
That's correct, Your Honor. That's our agreement.
All right. Mr. Pettis, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jose Perez III.
All right, so what drugs are you using?
I'm using methamphetamine
All right, how often?
every month. Every day, basically.
All right, so here's the thing. You got to be honest with me
Yes, ma'am.
because they've come to an agreement. I'm inclined to follow it, but in order for me to follow it, I need to give you conditions. So hopefully, whatever your issues are, you can get a control of them. You understand?
Yes, ma'am.
So you're using meth every day?
Yes, ma'am.
All right. Felony drug court is at capacity. But I think you need inpatient treatment, which is what everybody's suggesting you need.
Yes, Your
So
Honor.
what I can do is I can deny the motion, alternate main conditions, and I'll have you go to SATA. And I'll ask probation to make sure that you're still referred to felony drug court. So maybe once you're released from SATA, you can go into felony drug court.
Yes, Your Honor.
So even though SATA will address some issues, I don't think that's going to be enough for you with a daily meth use. I think you'll need felony drug court as well. Do you understand?
Yes, Your Honor.
All right. This is what the court will do then. The court will deny the motion, alternate amend conditions to include SATA with aftercare and a referral to felony drug court. Taking consideration NIMAC number 729016, 729015. And there'll be daily sober support meetings until accepted into felony drug court. And I know that seems like a punishment, but until you're accepted in felony drug court, you got to keep your mind busy and you got to keep your mind on your sobriety 100%. It can't get distracted at all because otherwise you'll probably be back here again for a possession of a meth case. And I understand the only difference from somebody possessing meth who has a drug problem is they didn't get a chance to use it. So understand?
Sure.
Is there anything you need from the court to be successful other than what we've given you?
No, ma'am.
All right. Thank you.
Thank you. Thank you, Judge.
Thank you.